The Renters' Rights Bill is coming back for debate on the 22nd of April, reaches committee stage in the House of Lords. It is at this stage that amendments from members of the Lord are debated and concerns that they may have are discussed. Most of these amendments that are put forward don't have the support of the government, and so therefore they're very unlikely to pass. However, sometimes the government does introduce some amendments of their own, and that has happened this week. And one of the new government amendments is actually quite helpful to landlords, as it addresses our concerns around the transition to the new tenancy regime, and gives landlords a little bit of certainty that they'll be able to regain possession where they've served the notice at some point between the bill passing through Parliament and the bill's commencement date, which is when it's actually coming into law. So what happens in those cases? Well, if you serve the Section 21 or Section 8 notice before the bill comes into force on the commencement date, then you will have a 3-month window in which to apply to court and regain possession of your property via a possession order if the tenants don't move out. Now, once this window passes, if the landlord hasn't begun possession proceedings, then the notice will expire and the landlord will have to restart the whole possession proceedings again using new grounds for Section 8 and the new notice periods. The problem with the original wording in the bill, though, was that beginning possession proceedings doesn't mean what you think it does, which is you applying to court. It actually meant that you had to apply to court, have the courts process the claim, and then issue you with the claim. This can take months in some courts. And so what could have ended up happening was you as the landlord could have served a notice, you could have applied to court for possession, and then through no fault of your own, because of court delays, your possession claim could have been thrown out because you missed the 3-month window for transition. And we've raised this as a concern with the government because we know that certain courts, particularly in London, are facing significant delays in issuing claims. And we're very pleased to see that the government has accepted this is a serious concern, and they have amended the Renters' Rights Bill, or proposed an amendment to the Renters' Rights Bill this week that would mean that any claim that is requested, i.e. sent in by the landlord in the 3-month window after the transition period starts, would actually be valid and would continue. The NRLA has raised this a number of times with the government. We are pleased to see the latest developments fix this. The new government amendment makes it clear that landlords can use a valid Section 21 or Section 8 notice to apply to court at any point during the 3-month transition window. Once the landlord has applied, the courts will treat that application as a valid application, and those notices will remain valid until the court has held a hearing and decided whether or not you should have a possession order, and if you need to, made it onto a bail.